I feel good, and that is smiling from heaven. That's all I wanted to say. Thank you, Lord.
On the ground that forgery was proved, it really and truly wasn't. Forgery, by virtue of the law, requires an intent to defraud to be established, and as that intent was absent, they couldn't adjudge the appellants as being guilty of that offense. It's required under all law that the prescribed offenses be proved in order to prove money laundering, and those prescribed offenses were never established. So in reality, the case should not have been sent to the jury. That basically is where this came down. From the onset, I believe that the allegations were unfounded, that the FIU basically sensationalized a situation in order to gain public favor, but ultimately, as it was shown, they did not have the evidence to prove the allegations that they brought against my clients. In that regard, it is sad because lives were destroyed as a result of this. And certainly, by virtue of what was put out there in the public, there will always be a stigma and suspicion arising over what has transpired or what did not transpire. This has been more than a 4-year ordeal. Actually, 5 years. And right now, I believe prudence would require us to take our time and savor the fact that justice prevailed. And after sufficient time, my clients will make up their minds as to what they want to do.
Now, sir, any indication that the FIU will appeal the Court of Appeals decision?
Can they appeal?
I don't believe so. There's really and truly, again, there was an absence of evidence in this matter. Allow me to say this. The monies at 12 Johnson Street really and truly had nothing to do with the business at the corner of Mahogany Street and the Central American Boulevard. Those monies, from what the evidence showed, were being withdrawn from the year 2000, some 7 years before the business was even started. All those monies had bank wrappers on them, had bank teller signatures on them, and again, if the investigation was properly done, I don't believe a case would have been brought. The Money Laundering Act 104 of Belize has been repealed. There's a new law in place now. So the law that was brought, was relied upon by the prosecution in this matter, will no longer be the law going forward. What was being tackled in relation to fraud and forgery is that fraud is listed as one of the prescribed offenses under the old law, the law that was used in this case. But fraud, there is no offense of fraud, there is no penalty for fraud. And fraud in and of itself requires the intent to defraud, which is that somebody loses while the other person who commits the act gains. Likewise, forgery requires the same intent to defraud. So where a person does not suffer loss and the other person did not gain by virtue of that person's loss, the forgery cannot be established. That intent must be there.